Thank you, Mr. Hivner. You may call the next case when you're ready.
Emergency Medical Care Facilities, PC versus Division of TennCare et al.
Good morning. Greg Reynolds for the Appellant Emergency Medical Care Facilities, EMCA. Whether TennCare can cut the pay of emergency physicians across the state simply by clicking send on an email with no notice, no right to comment, no input at all from the regulated physicians or from the public. The answer I would submit to the court is a resounding no for several reasons. First, TennCare's pay cut for emergency physicians constitutes a rule that must be promulgated under the Uniform Administrative Procedures Act. This $50 cap was not promulgated under the UAPA. It is therefore void. It does not fit within the exception on which TennCare relies, that is, the internal management exception. It also is not saved by 71-5-102D, an enabling statute that TennCare contends grants it what I have dubbed super agency authority when it engages in cost-cutting measures. Finally, a separate statute, 71-5-105A3A, specifically requires TennCare to engage in rulemaking, whereas here it determines payment for contracted providers. TennCare makes two arguments as to why the $50 cap does not constitute a rule. The first of those is that it is not a statement of general applicability. The requirement to be a rule is under 4-5-10212 of the Tennessee Code Annotated. That provision says that a rule is, quote, an agency statement of general applicability that implements or prescribes law or policy. TennCare's first argument that it is not generally applicable is that even though the $50 cap applies to every emergency physician in the state, that it isn't generally applicable because it doesn't apply to every patient that every emergency physician in the state sees. TennCare says now, and this has changed over time, but now TennCare says that, well, the $50 cap doesn't apply to patients that turn out to really have an emergency condition. But the fact that the $50 cap may not apply to every patient that the physician sees doesn't have any bearing on whether it is generally applicable to every emergency physician in the state. I don't think that point is seriously disputed. In short, TennCare's argument regarding general applicability lacks any support in the language of the UAPA, in its history, and the Court of Appeals correctly rejected it. TennCare's second argument that the $50 cap does not constitute a rule is frankly more weighty. It is where I think the crux of this case lies. TennCare argues that the so-called internal management exemption applies, and that is found in 4-5-10212A. That section of the UAPA provides a limited exception to the definition of a rule for, quote, statements concerning only the internal management of state government and not affecting private rights, privileges, or procedures available to the public. So we see from the language that each of two restrictions must be satisfied in order for the internal management exception to apply. The statement must concern only the internal management of state government and must not affect private rights, privileges, or procedures available to the public. Here, the $50 cap satisfies exactly neither of those two restrictions. As TennCare even admits, it concerns thousands of persons outside of state government, the participating providers. And it certainly affects their private rights by cutting their pay.
Mr. Reynolds, let me jump in here, and I want to flesh out a little bit more, what I guess the extent of your position. So let's imagine that the state entered into these physician agreements, but specified in the agreement. There's actually, a line in the agreement that says reimbursement for non-emergent care will be capped at $50. Would that satisfy the internal management exception, or is it your position that the UAPA precludes the state from entering into agreements of that sort with third parties when it's part of a regulatory program? Let's say that.
Yes.
So not,
Yes.
not some sort of proprietary function, but when it's part of a regulatory program.
Yeah, that's a very good question. And I would say it like this, that if it's specifically written into the contract between the provider as a one-off, the provider and TennCare, and it specifies what the provider shall be paid, that's not an internal management matter, that's a matter of contract. Outside of that context, when you're dealing with imposing something that fits the definition of a rule as the $50 cap does, because remember, it applies whether the provider is in network with an MCO or out of network with an MCO. It applies across the board to all providers. Something like that cannot be put in a contract and relieve the agency of its obligation under the UAPA. And it must be that way. And it must be that way because the legislature, the General Assembly, has made the decision that the UAPA is the law in Tennessee, and it's the law in the Tennessee for a good reason. It preserves a modicum of democracy. It puts it into the path of unelected bureaucrats. It makes them accountable in some small measure to the public, to the regulated community for their actions. And so if something fits the definition of a rule, and here it does, then an agency can't escape the obligation to promulgate it as a rule simply by slipping something into a one-page form provider agreement.
Mr. Reynolds, is there anything in the record to indicate how TennCare has approached these sorts of rate changes in the past? Whether it has done them, whether it has accomplished them via rulemaking or, via something more akin to what happened in this case? Indeed.
There are two instances that I'm aware of, have personal knowledge of, in which the agency capped reimbursement to hospitals for emergency services. TennCare didn't do that by email. It didn't click send and make it so. Instead, it engaged in rulemaking. There is what we have referred to in other litigation as the 74% rule that applies to outpatient emergency services for hospitals. And there's a 57% rule that was promulgated a couple of years later called the 57% rule. Also applies to inpatient services, emergency services for hospitals.
Mr. Reynolds, if I may interrupt you for just a second, I want to clarify something. I know Justice Campbell asked you if there's anything in the record, and in your recitation of that, you said, I have personal knowledge of this. Is this particular information that you're relaying now in the record of the case before us?
I believe it has been cited in the briefing, Your Honor.
Is it something that's publicly available, like something that?
It certainly is. It is promulgated in the official rules and regulations of the agency. So, in
So does it-
effect,
sorry to interrupt again, but I just want to go back to, I guess, my initial question about, you know, whether TennCare could put something like this in a contract. I think in your answer you suggested that the answer to that may turn on, you know, whether TennCare is trying to achieve kind of an across-the-board change that applies to all providers, or, you know, whether it's kind of a one-off contract. Am I understanding that correctly?
yes,
And so would
yes.
that go to whether it's generally applicable, or would that go to whether it falls within the internal management exception?
I think that would go toward whether it constitutes a rule. If it is generally applicable, then it's going to satisfy that prong of the requirements for a rule. And I don't believe that the statute permits the agency to contract around its requirement to engage in rulemaking when the statement that it is putting in place is a rule.
Well,
Mr. Reynolds, this letter you talked about being sent by email was in July of 2011, right?
It was, yes,
This suit
sir.
was not filed in Chancery Court until September of 2018. As a policy matter, should we be concerned with that delay while all these damages, I guess, built up over time?
No, I don't think so. For one thing, I would submit that this court has the obligation to get it right now. We've gotten it before the court. It did take a little while to do that, and I understand that there may be some concern in that respect. However, that does not detract from the issues that are before this court. They're very important here. I think it's really what we have here is that this $50 cap doesn't fit within the existing language of Tennessee law for the internal management exception. And so, in effect, what the Court of Appeals has done and what TennCare advocates is to effectively engraft onto the existing language of 102-12A an exception for privity of contract that doesn't exist anywhere in the language or history of the statute. I would submit that the only support that the agency or the Court of Appeals could derive for that, what I would call a new exception, comes in the Tennessee community case, which is cited in everyone's briefs. But the Tennessee community case is easily distinguishable from this one. And it doesn't support the notion that TennCare argues it for. That is that in this case, the court should allow it to impose the $50 cap without going through rulemaking. In that case, a separate statutory scheme authorized the Tennessee Department of Intellectual and Developmental Disabilities, TDID, that's a mouthful, to promulgate operating guidelines and to do so without going through the UAPA. But even so, the court noted that under that statutory framework, it still could not take actions, quote, for determining payment to service providers. That would require rulemaking under the UAPA. So it doesn't support their argument here. Furthermore, the Tennessee community case didn't have any analysis of the language of the statute. It was threadbare, to say the least. In another case, the Tennessee Court of Appeals rejected a similar argument for a privity of contract exception to rulemaking. In the Heritage case, which we've cited, the Court of Appeals rejected a similar attempt by the Tennessee Department of Human Services, arguing that its provider agreement gave the agency a contractual right to enforce unadopted rules that it had in its policies and procedures manual that was incorporated by reference into the provider agreement. So you see, the Court of Appeals recognized this trick once before and got it right in the Heritage case. Likewise, high courts in other states have agreed that arguments by Medicaid agencies that provider agreements can excuse them from their rulemaking obligations will not fly. One of those was the Missouri Supreme Court case in NME hospitals. I think we cited that at pages 38 and 39 of our application. In that case, the court decided a purported change in statewide policy that does not comply with rulemaking procedures is not enforceable by contract. And it noted further, quote, states have uniformly held that state agencies may not evade rulemaking by contract. We need a bright line rule here that TennCare can't avoid, and state agencies can't avoid rulemaking. If it's a rule, it's got to be promulgated as a rule. If it's not, that's something entirely different. But that's what's needed in order to protect the UAPA and what it envisions.
Counsel, this is Justice Lee. I have a question for you. If we agree with you that this cap should have been promulgated as a rule, will that apply only to your client or to everyone, every emergency provider who may receive payment?
It would apply across the board because the ruling would be that the $50 cap is void and of no effect. And under 4-5-216, it cannot be enforced against anyone, and the agency can't use it for any purpose. So it would cover the entire group.
If this had been done as you said it should have been done, how long would that have taken?
That's a good question. And I'm glad that you asked that because I had forgotten to raise that. The UAPA includes a provision specifically that authorizes emergency rules. And that provision makes the agency statement, if it fits within the emergency rule statute, immediately effective. And in fact, that's what TennCare initially promised to do here. TennCare wrote on April 8th that it was going to promulgate, quote, promulgate emergency rules before July 1 requiring that these cuts, and what I'm referring to is the $50 cap, requiring it that these cuts be made, thereby making it state law and regulation. So the UAPA is no barrier to sound governance, as TennCare seems to imply. It is, in fact, the vehicle that TennCare needs to use if it's going to impose statewide requirements as it did here.
Well, Council, what would be the process for promulgating these emergency rules? What would they actually have had to do to issue the rule on an emergency basis?
Well, Your Honor, I cannot claim to be an expert on that internal aspect of how that works, but I can say this, that the promulgation of an emergency rule makes it immediately effective, and effective for a period of 6 months. I think it's 180 days. Within that time, the agency can then go through formal rulemaking procedures. And so while I don't know exactly the procedure, what comes next and what comes next, that is my understanding as to how it works, Your Honor.
But you're basically saying it's a fairly quick procedure to issue an emergency rule.
Yes, indeed.
All right, thank you.
TennCare also argues that 71-5-102D exempts it broadly from rulemaking whenever it acts to control costs. But an examination of that statute shows nothing of the sort. It's really an enabling statute, and it doesn't contain any language exempting TennCare from rulemaking. TennCare asks the court simply to infer such a legislative purpose. But the General Assembly knew how to exempt TennCare from rulemaking when it wished to do so, and it did so expressly, not implicitly. In Section 15 of the very public act that resulted in the amendments to 102D that TennCare relies upon, Section 15, the General Assembly expressly exempted TennCare from rulemaking for a preferred drug list, and it expressly provided that TennCare's adoption and amendment of the preferred drug list, quote, are not agency actions and do not require rulemaking, close quote. So the General Assembly knew exactly how to do it when they wished to do it. In the very legislation, they specifically exempted only one thing, not everything else. Finally, a separate statute, Section 71-5-105A3A, also requires specifically that TennCare engage in rulemaking, whereas here it has determined payment to participating providers. TennCare concedes that it used to provide for rulemaking, used to require rulemaking when, as here, it was determining rates for providers. And I would submit that the language hasn't changed. I see my time is up, and I'll reserve the rest of my time for rebuttal.
Thank you.
Thank you.
May it please the court. Good morning. I'm Matthew Dykstra with the Tennessee Attorney General's Office, and I represent TennCare in this matter. TennCare should prevail for 3 reasons. First, the $50 cap does not meet the UAPA's general definition of a rule. Second, even if it did, it satisfies the UAPA's internal management exception to that general rule. Third and last, the Tennessee Medical Assistance Act does not provide otherwise. In fact, it grants TennCare a rulemaking exemption for cost control measures like the $50 cap. Now, if this court agrees with TennCare on any one of these 3 points, TennCare prevails on this appeal. Conversely, EMCF has to run the table to prevail. Let's first talk about the general definition of a rule. As Mr. Reynolds recounted, a rule is defined in our code at 4-5-102 subparagraph 12. And it says, a rule means any statement of general applicability that implements law or policy. So, from the outset, that language tells us that not every agency statement, even if it implements law or policy, will constitute a rule. Instead, only those agency statements that are generally applicable will constitute a rule. So that phrase.
So how do you're probably getting to this, but how do you define generally applicable?
I think the answer is that you can't have a one-size-fits-all test. That it is going to be agency-specific, it's going to be statement-specific.
So for TennCare, what does that mean? What would be something that is generally applicable that TennCare does or issues?
TennCare regularly issues rules. I mean, right now there's almost 200 rules on the books for TennCare. They go from TennCare, enrollee eligibility, appeal rights.
So what sets those apart from this with respect to the generally applicable requirement?
Again, that's where I recognize that there may be a problem formulating a one-size-fits-all test. I think you have to look at every agency statement.
But don't we have to come up with, sorry, this is Justice Kirby, don't we have to come up to, just to follow up on Justice Campbell's question, don't we have to articulate? Don't we have to give some kind of standard? And I think that's what she is asking. We can't just say, we'll look at every set of facts and we'll get back to you. We have to articulate some kind of organizing or limiting principle.
Again, I don't know if that's feasible in a one-size-all approach. I think you do have to look at every agency statement and you have to look at the facts. And under these facts, it's a very, very narrow application for this agency statement. It only applies, to go back to the general applicability part, TennCare's argument here really springs from the premise that there has to be agency statements that are specific enough that they are not generally applicable. And we submit that's the case here. Because the $50 cap did not apply to all healthcare providers. It did not even apply to all emergency room providers. Instead, it narrowly applied to emergency room providers who contracted with TennCare and that provided non-emergent care in emergency rooms, There, a subset of a subset of a subset is, I think, sufficient in this case, even if it's hard to formulate a bright line test.
Who was this sent to? Who was the email sent to?
It was sent to, first, I believe, MCOs, and then MCOs down to providers.
So was it sent to this very narrow group that you mentioned? Or was it sent more broadly and it just so happens that it may only have relevance to a subset of those providers who happen to do all of these things that you mentioned?
I apologize, Your Honor. I don't know the answer to that question, and I'm not sure if it's in the record. Either Mr. Reynolds may know the answer to that or not, and I'll let him speak to it. But
wouldn't you agree that, I mean, there are certainly rules and regulations that are on the books that apply generally, in the sense that anyone to whom they are relevant would be subject to them. But they might only be relevant to some subset of entities. Would you agree with that?
I do.
I mean, isn't that really what the situation that we have here? I mean, it's not that you're choosing among entities that this would be relevant to and only applying it to those, a subset of them. It's just that this cap is only relevant to entities that check all the boxes that you mentioned a moment ago.
Correct, only applicable to a very narrow group of providers. And that's,
I think maybe we're using that term a little bit differently. I mean, applicable, if there's an entity out there that suddenly starts offering ER services and providing, or opens up an ER and starts providing non-emergent services in that ER, and has an agreement with TennCare, they would then come under this cap, right?
that's correct, Your Honor.
Okay, so it's, I may be parsing words here, but I guess to me, I see a difference between sort of applicable to and relevant to. You seem to disagree with that.
I don't think I do. I mean, maybe I'm not understanding the distinction. TennCare's point is just that with this agency statement, it is very specific. And we think that it is narrow enough to avoid a general applicability finding. But the definition of a rule doesn't stop there, because in the general definition of a rule, there's an exception. This internal management exception.
But doesn't it, excuse me, before you go on to the internal operating exception, I do want you to address that, but I'm trying to conceptualize what you're talking about and what Justice Campbell is talking about. For example, we have rules of civil procedure that apply to counterclaims. They only apply to the people who file counterclaims. But if anyone files a counterclaim, it's going to apply to them. I may be misstating, but that's kind of how I'm conceptualizing what she's articulating. There's a difference between these rules only apply to a contracted subset, for example. But so, in other words, that's the terms of what is articulated in the rule or in the promulgation. If that's the only thing that, if it only makes it relevant to a certain subset, but anybody who comes within that subset, isn't that a rule? Isn't that generally applicable?
Well, it's before this court to determine the confines of general applicability, and it hasn't been fleshed out before. And it's TennCare's position that the $50 cap really is narrow, even if it's an open category that would apply to a new physician group, as Justice Campbell mentioned. Even in that case, we think it still has a specific enough application to fall outside the general definition.
I mean, I'm really having a problem with the argument here, because you're saying, well, this one's narrow enough, but you're not offering us any sort of principle to guide agencies going forward who must decide prospectively at the outset, is this something that needs to be issued via rulemaking or not? We can't, I'm speaking only for myself here, but I don't think that we can, decide this question based just on the facts of this case. I mean, we've got to offer something that provides some guiding principles to agencies going forward. Do you want to try one more time, I guess, to do that, or are you really saying that it's going to depend case by case on the specific facts?
And let me piggyback on that to bring in the aspect that Mr. Reynolds brought up about prior times. He mentioned 2 times in which the agency capped reimbursements to hospitals by using rulemaking. So, as a part of what Justice Campbell's saying, where is the line? Where is the line given that distinction? Well, the line
In that instance was because it was required by federal law. That is not the case with the $50 cap.
Can you elaborate on that a
Sure.
bit? What exactly was required by federal law?
It's a whole other case with a lengthy history that I did not provide representation to TennCare on. So I'll try and hit the high notes, and I apologize if I again, 100% correct. But it provided a 50% and 70% rule for reimbursements, and they were promulgated to make sure that Tennessee state law complied with the Tennessee State Plan Amendment, the Medicaid plan that's approved by CMS, and they were enacted in order to comply with the Federal Reduction Act. That's a snapshot of those rules in that case, and that is the Erlanger case.
You would acknowledge, though, that in this case, with respect specifically to the cap at issue in this case, the initial communications that went out indicated that this cap would be achieved by emergency rulemaking. Is that correct?
Correct. And then TennCare reversed course and said that it would not be implementing it by rulemaking. And respectfully, what one employee of TennCare thought about TennCare's rulemaking obligations is not what matters. What matters is what this court thinks about TennCare's rulemaking obligations. If the employee had sent out an email that initially said TennCare is not bound to rulemaking, it wouldn't have any more relevance than the converse. What matters is what this court thinks.
Counsel, this is Justice Lee. Does the record show why TennCare reversed its policy and did not go through emergency rulemaking?
Not to my knowledge, Your Honor, no.
We keep asking you about the definition of general applicability. You seem to be saying that this only applies to a narrow subset of a subset, which would indicate you're looking at it in terms of numbers of providers that it applies to. In other words, you're saying this may only apply to 5% of the providers, therefore it's not generally applicable. Would that be fair to say?
Yes, that is one measure, Your Honor. The total number of providers in the state versus the number of providers that this cap would apply to is not in the record, though.
Okay, what if it applied to 20% of the providers? I'm still struggling with the definition of general applicability. If we're doing it based on the number of providers affected, then we've got to have an idea as at what point does it become significant enough that it becomes generally applicable, in your view? Does it have to apply to 90% of the providers, 50%, 30%?
Certainly, I think if
and we don't know in this record, do we, how many providers are actually affected?
We do not know on this record, Your Honor. This was a question or an issue that, frankly, I had a hard time preparing for because I do think it is fact specific. It is specific to the agency statement, and I recognize the court's concern that this would potentially.
I would like for you to address your other two arguments, starting with the internal management exception.
Thank you, Your Honor. The definition of rule contains exceptions. The exception relevant here is the internal management exception. And it says that even if a statement is generally applicable, it is still not a rule if it only concerns the internal management of state government and does not affect private rights, privileges, or procedures available to the public. Our courts have only examined this exception with respect to contracted entities on one occasion, and that is the Tennessee Community Organizations case that Mr. Reynolds referenced. There, a state agency imposed sanctions on healthcare providers for billing hours in excess of a federal cap. Our Court of Appeals held that the sanctions policy satisfied the internal management exception because it, quote, was mandatory only on agency employees and contracted entities. The court therefore held that it did not bear on private rights, privileges, or procedures available to the public. Recognizing that the internal management exception applies and is satisfied to employees and contracted entities makes sense because both of those relationships are voluntary and both relationships involve or concern carrying out the management of state services and functions. TennCare submits the Tennessee Community Organizations Court got it right with its analysis of the internal management exception. And that is exactly the situation here. The $50 cap is only applicable to entities that have voluntarily signed a provider participation agreement with TennCare. Thus, the $50 cap is not a rule because it satisfies the internal management exception by only applying to contracted entities.
So how far does your position go? Does that mean then that anytime a state agency contracts with third-party entities to administer a government program, that they are then effectively immunized from the UAPA's rulemaking requirements? They can just, if they have a contract with these third parties that says you agree to comply with, anything we say you have to do in the future, then are they able to just send an email imposing new requirements and are no longer obligated to comply with rulemaking requirements? And if that's not your position, I guess where's the line?
I'm trying not to blend the issues too much, but it does depend on the agency's enabling statute and the other legislation that governs the agency's operations. So I would say, as a general principle, I agree that an agency cannot evade rulemaking through contract. That is not what's happening with TennCare, though. TennCare has almost 200 rules on the books, including provider reimbursement rules when federal law requires it, including provider reimbursement rules when TennCare has a direct payor relationship with providers. It has rules, a lot of rules related to enrollees regarding eligibility, scope of services, appeals. TennCare engages in rulemaking. It just does not engage in rulemaking when it has a contract in the managed care context. That is, it is not a payor for the services rendered, and instead managed care organizations are. And to go one step further, in that context, TennCare also has a rule for the payment, which is two rules actually. There's the full payment rule and the 80% rule, which is if you're in network providers, you have to accept 100% of the MCO payment. If you're out of network, you accept 80% of what the in-network providers are paid. That's all done through rulemaking.
Why was that done via rulemaking and this was not? What's the distinction there?
Well,
those are rules that apply to providers that presumably would have agreements with TennCare, correct?
Correct.
So is there a reason, was that required by federal law, or is there some other provision of state law that required rulemaking in that instance?
I don't think the record is clear on why it was done, but I think the rules satisfy the statute, and I'm jumping around here, but that would be 71.5.105 A3A, which says rules for the determination of payment. And those rules do determine payments. Now, they don't set out fee schedules, but I think that the full payment rule and the 80% rule satisfy to the extent that A3A applies to TennCare.
But why isn't this similar? I mean, it doesn't set out a fee schedule, but it does set out a cap.
Similar to, I'm sorry, I don't know if I understand the question, Your Honor.
I think that you indicated that those rules didn't set out a fee schedule, but they set out parameters, apparently.
Correct, two rules.
And I haven't seen them, so I don't know them. But here, it doesn't set a fee schedule, but it just sets a cap. It can be anything up. So that's more in the nature of a parameter. I'm trying to figure out how this situation differs from the ones you have contrasted, where there are actual rules regarding fees.
Well, this situation would fall within those existing rules.
Okay, I'm sorry, I'm not able to articulate my question more clearly. You can go on.
So is the bottom line of what you're saying is TennCare could choose to do this by rulemaking, or could choose to do it without rulemaking?
No, that is not my position, Your Honor. My position is that when TennCare is obligated to engage in rulemaking, it does. When it is not obligated to engage in rulemaking for cost control measures like the $50 cap, it does not. And our brief tried to lay out that reality, that there are situations where TennCare is obligated to engage in rulemaking, and there are situations where they are not. And that's where I don't agree with Mr. Reynolds on his view of TennCare as a super agency.
Mr. Doxer, before you run out of time, I want to ask you about 715102D.
Yes, Your Honor.
The Court of Appeals never reached that issue because they relied on the internal management exception. And in the reply brief, the appellant did a really good job of addressing your argument. I want to give you a chance to talk about it before we run out of time.
Yes, thank you, Your Honor. So in 102D was enacted in 2004. That was about a decade into 10 years into TennCare's experiment with managed care. The experiment wasn't going too well. TennCare was consuming 90%, or soon would consume 90% of all new state revenue. Simply put, costs were out of hand. TennCare was not going to survive in its current format. Against that backdrop, 715102D was enacted. It was a momentous and historic piece of legislation to save TennCare by giving TennCare broad cost control authority. Before we talk about that statute's effect on rulemaking, I'd like to first talk about a related threshold issue. And that's, are provider costs within the scope of the statute, or is the statute only limited to enrollee costs? First, let's start with the plain language of the statute. Its first sentence, which we denoted as segment A in our brief, says that TennCare shall have the authority to control the cost of the TennCare program to the extent permitted under federal law on the TennCare waiver. This language speaks to costs generally. It does not speak solely to enrollee costs. EMCF thus reads a limitation into the statute that does not exist in its text. Second, the public act behind the statute says it was enacted to control the overall expenditure of TennCare. Excluding provider costs from the statute simply cannot be reconciled with the phrase overall expenditures. Now, I don't think there's any ambiguity in the text, but if the court thinks so, Governor Bryson's speech highlights that 102D, as we've been referring here, was enacted as a global solution to TennCare's rising costs. His speech, in fact, was entitled Saving TennCare. Respectfully, I don't think a statute designed to save a program that consumes 20% of the state's budget nibbles around the edges. No, this was to impact structural reform within TennCare. In fact, Governor Bryson specifically mentioned providers and how the state needed to take the reins back from providers and how the state would determine how much and for what we are going to pay.
Mr. Dykstra, was there anything in that, let's assume that the speech is relevant, which I would disagree with, but to the extent the speech is relevant, is there anything in that speech that addresses the UAPA and its rulemaking requirements?
No, Your Honor.
Okay, so in what way is that indicative of how we should interpret the statute with respect to the UAPA's rulemaking requirements?
Your Honor, to the extent that first the statute was intended to encompass both provider and enrollment costs and to give TennCare broad authority. I don't think referencing the UAPA is necessary, whether it be in a speech or in an actual statute. That's the Mandela case from this court that we cited in our brief. There, this court held that a statute that gave the Department of Corrections broad authority over management, supervision, and fiscal administration, except as otherwise provided.
Would you agree that TennCare, there are instances in which TennCare can exercise emergency rulemaking authority?
Yes, Your Honor, there are instances, and the duty to engage in emergency rulemaking is derivative from the duty to engage in rulemaking in the first instance. And TennCare submits that it did not have a duty to engage in rulemaking for the $50 cap.
But I guess what I'm getting at is, even if it's true that the purpose of this was to kind of take back some control from providers, I mean, that doesn't necessarily mean that that TennCare then doesn't have to engage in rulemaking. There are ways that TennCare can engage in rulemaking that is immediately effective, that allows it to immediately achieve its objective via emergency rulemaking. And that's, in fact, exactly what TennCare initially indicated that it was going to do in this situation with respect to the cap on non-emergent services, was to accomplish that by emergency rulemaking. Isn't that right?
Correct, that they stated they would initially engage in emergency rulemaking, correct. But I think we have to go back to the statutory text here on 102D. Again, this was a momentous piece of legislation. It was enacted in lieu of a state income tax. I don't think we can downplay the significance of 102D. When it was enacted in 2004, TennCare simply was not going to survive. Since the time it has been enacted, TennCare has saved the state $22 billion. That's state dollars.
So let me see if I understand what you're saying. You're emphasizing how broad this is. And as I understand your argument, you're saying that it is so broad that if the measure implicated by TennCare cuts costs, then TennCare does not have to engage in rulemaking? Is that fair?
Yes, Your Honor, for cost control measures. And here, in this case.
So if TennCare conversely were to raise the cap here to $75, then it would have to engage in rulemaking, all of that sort of thing. But if whatever TennCare does, if it has the effect of cutting TennCare's costs, then that overrides the UAPA, overrides TennCare's obligation to engage in rulemaking.
Correct. For provider costs for which, provider reimbursements, provider costs for which
Well, this
TennCare
would be
does not.
any kind of cost, right? I mean, under the principle that you are articulating, not limited to providers. It's anything that cuts TennCare's costs.
The statutory language could go that far. TennCare has not gone that far. TennCare has used its powers in 102D solely.
Well, how would what's a limiting principle? I mean, the only limiting principle that I hear from you is if the effect of it is to cut costs. Is that the limiting principle that you are asking us to adopt? What other?
Yes, I believe that's the limit within the statute. And
Okay.
TennCare's CFO executed a declaration in this case, which was unchallenged, that said the purpose of the $50 cap was solely for cost control measures.
Okay.
So the $50 cap fits within the scope of 102D.
Mr. Dykstra, I'd like to just focus on the text of that provision of 102D. Can you explain, I guess, what in the text of the statute provides or I guess indicates that your position on this is correct, that rulemaking is not required if whatever decision TennCare is making is for the purpose of cost control?
Sure. I look at the statute, I think it's for me at least, it makes most sense to look at the bookends. So we've identified segment A and segment D. And segment A says, TennCare shall have the authority to control costs to the extent permitted under federal law and the TennCare waiver. So the state is saying any power you have under federal law, you have the full extent of that power. And the TennCare waiver there, what TennCare waiver means is managed care. Managed care is done through contracts. So the General Assembly is saying whatever you have under federal law and whatever you can do with your managed care contracts, you have that authority. That's segment A. And if we look at segment D, it vests TennCare, apologize. Segment D then ends the statute by saying TennCare has that authority notwithstanding any other state law to the contrary. That is that's a statement of congressional intent that is very clear. This court stated that in the Perky case that we cited in our brief. You don't need to state or list enumerated laws to trump them when you have a broad statute like that. So again, I think context matters with 102D. It was enacted when TennCare was not going to survive. Again, I don't think you can downplay the scope of it. It was enacted in lieu of a state income tax. And I think when you look at it, the General Assembly was giving TennCare all the authority that it could. And it's worked. And it's worked. In closing, Your Honors, for the reasons argued and submitted by TennCare, the Court of Appeals holding on general applicability should be reversed. Alternatively, the Court of Appeals holding that the $50 cap satisfies the internal management exception should be affirmed. And last, if the court need reach the issue, that Section 71.5.102D provides TennCare with an exemption from rulemaking for cost control measures like the $50 cap.
Thank you, Mr. Baxter.
Thank you.
Rebuttal?
We didn't think you were going to waive it.
We were hoping, though.
I will be brief, probably famous last words. There are two broad things I'd like to cover quickly, if I may. First, I didn't hear an answer to Justice Campbell's question about what does generally applicable mean within the context of the UAPA. Thankfully, there is an answer. The statute as adopted in Tennessee was derived from the Uniform Act. The Uniform Act dates back to 1961. And what we have cited on page 6 and 7 of our brief is the official comment to Section 1 of that Model State Administrative Procedures Act of 1961, which says, attention should be called to the fact that rules, like statutory provisions, may be of general applicability, even though they may be of immediate concern to only a single person or corporation, provided the form is general and others who may qualify in the future will fall within its provisions, close quote. In other words, what general applicability means is, does the statement look forward? And does it apply to a group whose constituents may change over time? That's the answer. Here, the $50 cap applies to a group, emergency physicians. It's forward-looking. It applies next week. It applies in 10 years unless this court does something about it. And the members of that group can change over time. That's what general applicability means, at least in the minds of those who produced the Uniform Act. Second, the internal management exemption. I believe I heard Mr. Dykstra say that the provision within Section 102D that gives TennCare trump card power is the last sentence. That last sentence reads, quote, the Bureau of TennCare shall have all such authority to control costs notwithstanding any other state law to the contrary. Close
That's not
quote.
the internal management exception. You said
No.
Okay.
This is.
I'm sorry. You
This is
said you
102D.
started by saying you were going to address that, but you go ahead and address the cost cutting. That's
Yes,
fine.
I was moving on to the 102D argument that
Gotcha.
Mr. Dykstra was
That's fine.
making. Second point, that language, I believe I heard Mr. Dykstra say was a trump card of sorts. But in order for a law to be trumped, according to the plain language of that statute, it has to be to the contrary. Here, the UAPA is not a contrary state law. How do we know this? Well, we know it, for one, because of TennCare's email where they first promised they were going to engage in emergency rulemaking to make the $50 cap state law and regulation. So we know it's not a contrary law. All it does is set forth notice and comment procedures that ensure that the public and the regulated community have a voice in their government. Some check, some balance against unelected bureaucrats running their lives. That's what's so important about adhering to the principles and the requirements of the UAPA. That's what's so important, that we can't let any agency, even a good agency like TennCare, decide that it can circumvent the UAPA and public notice, public comment, public scrutiny by entering into provider agreements. Only the legislature should be allowed to create exceptions that aren't in the statute. That shouldn't happen here. Thank you very much.
Thank you for your arguments. We're going to take about a 10-minute break and then take up our third case.
All rise. Honorable Court is now in recess.